Good afternoon, everybody. On behalf of the Centre for Legal History, it's my great pleasure to welcome you to the third and last Alan Watson Memorial Lecture. The first lecture, Enslaved and Enslavers in Scotland, led to the second, Managing the Enslaved. And so you can see the progression towards the last one, challenging, as you might expect, enslavement, where the speaker is going to look at some of the most crucial cases on slavery in their context in particular, and how the ambiguous, I'm sure you've seen that in the last lecture, the very ambiguous status of slavery in Scotland will be progressively clarified, and so slavery itself challenged. As I said, it's the last of three lectures by Professor John Cairns, so by now I'm pretty confident that you all know the speaker. I mean, I'm pretty sure that you already knew him before, but this means I don't need to introduce him. And it's a big relief for me, for two reasons. The first is that it would be rather presumptuous of me to introduce one of the most distinguished legal historians in Britain and beyond. I would say one of the most distinguished legal historians, full stop. And the second is because it's really difficult to do so. Where do you start? I mean, John is as eclectic, as prolific a scholar. Something that one of the other features that he shares, I would say, with the scholar we are honoring today, Professor Alan Watson. You think of legal education in Britain, particularly, but not only in Scotland, and the first name that pops up is that of Professor John Cairns. You think of codification, particularly in Louisiana, again, John Cairns. You think of Scottish Enlightenment and the law, again, John Cairns. You think of slavery in Scotland, again, John Cairns. That doesn't mean that these are the only subjects, huge as they are, on which John has been working for many years. You can think of a number of others, from juries in Britain to Scottish institutional writers to Roman law, several aspects, in fact, of Roman law, to comparative law, to the history of the legal profession, particularly, again, not only in Scotland, to the historiography of legal history, European and beyond, and particularly, again, Scottish legal history. I could even find an article on Tiberius Corucanus. So it's really, really difficult, so I'm not even going to try. So without further ado, I'll just leave the floor to John. Thank you.
Well, thank you, Guido. I feel kind of embarrassed now. I'm not quite certain how to start, but thank you. There's very, very kind remarks. Well, this is the final of the three lectures, and as Guido has said, there has been a progression of topics. But I thought I would start, as I've started each one, with some words about Alan. And one of the last articles Alan Watson published was on Lord Mansfield and Somerset's case. It had been prompted by his reading of Stephen Wise's then recent book, Though the Heavens May Fall. This was subtitled, and I quote, "The Landmark Trial That Led to the End of Human Slavery." And I expect that Alan had been somewhat irritated by the book and its argument. I mean, a trade rather than an academic book, the claim embodied in the subtitle is, of course, absurdly large. And Alan entitled his article, prompted by this book, Lord Mansfield, Judicial Integrity or Its Lack, Somerset's Case. He presented an ingenious argument. He pointed out that Lord Mansfield cited no authority. He suggested that Lord Mansfield wished to avoid giving a decision, as he knew that, even by the narrow view that all he was deciding, that masters could not send enslaved individuals abroad against their will, he was in effect emancipating the slaves. As I pointed out last week, the threat of forced return to the colonies was the most potent threat in which to keep individuals who were held in enslavement under control. And so it was one that gave great authority to masters. And Mansfield's decision removed that potent threat for England. Allen also pointed out that one issue never discussed by Mansfield in the case was conflict of laws. He noted that though through acting in Scottish cases, Mansfield was familiar with issues of conflict of laws, and that in particular he was familiar with the work of Ulrich Huber on conflicts of law. Those of you who attended my second lecture will recall the importance of Huber's influential view that slavery was contra naturam, but not contrary to natural law. Huber was also one of the most important theorists of conflicts of law, an issue, of course, of great importance in the northern Netherlands, where there were 7 sovereign provinces, each with their own laws, so conflicts of law was a big issue. And increasingly so, conflicts of law became increasingly a great issue of importance in Britain in the 18th century. Allen argued that Mansfield encouraged Stuart to compromise with Somerset in order to avoid the necessity of his having to give an opinion, either in favour of freedom from slavery or in favour of slavery through application of the law of Virginia through a conflicts doctrine. Allen also described Somerset's case as probably the most famous decision in English law. Well, it is certainly one of the best known. But one thing that's very interesting about the case is that there's so much uncertainty still surrounds it. Even to the extent of disagreement over its import, what actually was decided, and even uncertainty as to what Lord Mansfield actually said in his opinion. And this is a case, we must remember, that's been picked over many times by scholars and by lawyers. Until recently, the Scottish freedom cases, the final one of which, Knight against Wedderburn, resulted in a much more radical decision than Somerset's case, the Scottish cases have had very little attention paid to them. That is now changing. In contrast to Somerset's case, the Scottish cases, particularly that of Knight, are very well recorded. This is because of the nature of Scottish civil litigation in the period, which built up a dossier known as the process that ended up in the court's archive, preserved in the National Records of Scotland. Such processes may contain, in manuscript, written argument presented before the Lord Ordinary in the Outer House of the Court of Session, presented in the form of memorials, the interlocutors delivered by the court, as well as all other documentation relating to the case. In Knight's case, the Knight against Wedderburn, this amounts to 101 foolscap pages of written manuscript argument. At the same time, as cases proceeded through the Court of Session, oral argument would be reduced and developed in writing in what were known as informations, in order to assist the inner house. Often, initially, these are based on the manuscript memorials found in the processes. These informations could develop into very, very elaborate written pleadings. In Knight's case, there are 161 quarto pages of session papers of written argument. And this by no means exhausts the manuscript record of written argument found in Knight's case. One can find the argument in the Bill of Advocation, the argument presented before the Sheriff Court, which has all been written out and put into the process. Now, what this means is that Scottish 18th century cases create an extensive archive of legal argument, of opinions, and this gives one information that can give real insight into how people thought about issues and topics. A few years ago, one of my research students, who is an American attorney, which is relevant to what I'm about to say, called Liza Karzai, was working on session papers, and she very perceptively compared them to the famous Brandeis brief. That is an argument presented to the Supreme Court that focused more on social scientific and scientific argument than legal authority. And this explains some aspects of the cases that I shall discuss. I should probably also add, for those of you who are not familiar with them, that the session papers were generally preserved by individuals. And so there are multiple sets preserved in differing libraries. It's also important to note that until 1693, the Lords of Session advised, as the term was, in private. So there was no reasoned opinion of the court preserved as part of the record. simply the formal interlocutor or decreet. Even after this date, the judges expressed their views in public when they voted, as they voted at the end of the case. These opinions were not generally preserved by anyone reporting the decisions of the court. We do find that sometimes individuals made notes of what the judges said, and we have two versions preserved of what the judges said in Knight against Wedderburn. And in one of the other cases I shall discuss an indication of what they said. As I've already indicated, black individuals turn up in other litigation in Scotland. Just to remind you, last week I mentioned that the Scottish court debated the question of whether someone who was black and perhaps a slave could give evidence in a divorce case. Part of the issue being that he was not baptized and so could not take an oath. And this case developed all kinds of interesting discussions of what slavery was in Scotland and its memorials. But it was not eventually decided, or at least the case was decided, but the court very wisely decided to avoid completely whether they had to deal with the issue of whether this person could give evidence or not. They just circumvented it. I also mentioned the case of His Majesty's Advocate against Bell or Belinda, in which a Circuit Court of Justiciary effectively recognised enslavement in 1770, if it did so by an indirect route. But in this lecture, I will focus on three cases where the Court of Session was directly presented with the question of whether there could be slavery in Scotland. These cases are, first of all, Shedden against Montgomery, decided in 1757, Spence against Dalrymple, decided in 1770, and of course, Knight against Wedderburn, decided in 1778. In a lecture of under an hour, I can only touch on some of the arguments presented in these cases, of course. As I've mentioned, all this volume of documentation of legal argument that survives. And the cases have a great deal of argument, and being lawyers, they present all kinds of different arguments and alternatives to try to persuade the court of their view. The papers are also full of all kinds of interesting factual information. Though it must be remembered that factual claims are just that, claims. They were subject to potential proof or indeed disproof, and so they're just allegations. But they're presented as if they are true in the papers. I shall start with the first one, Shedden against Montgomery. In 1750, Robert Shedden bought a young black man called Jamie in Virginia. Shedden sent Jamie, whom he seems to have renamed Shanker, to Scotland to be trained as a joiner in Beath. John Witherspoon, then minister at Beath, baptized him under the name James Montgomery, and on 19th April 1756 gave him a certificate of his good Christian conduct. Shedden wished to return Montgomery to Virginia for sale, but Montgomery ran away. It is probable, given the arguments in the court, that he believed that his baptism had freed him from slavery, which, as we noticed last week, was a very popular belief in Britain. Montgomery made his way to Edinburgh and found employment as a journeyman. Remember, he's a trained wright, so he's got valuable skills. On the 4th May 1756, the Edinburgh Evening Advertiser carried the following notice. I shan't read it, but you can see the import. It's advertising for the return of Montgomery. He is described. One gets a physical description. You notice that his certificate of Christian conduct is mentioned. And there is a reward of 2 guineas. This advertisement led to Montgomery's arrest by one of the officers of the Bailey Court in Edinburgh, who duly received the reward of 2 guineas. Montgomery was imprisoned in the city guard. Shedden petitioned the Baileys for Montgomery to be delivered to him, pointing out the costs that he'd incurred. He said he deserved him because of the costs he'd incurred and looking after him, sending him here to be trained and so on. Well, arguing that, though the slavery of the Roman law might no longer be allowed, this is a common claim of this period, slavery had been permitted where required by, as he could say, public utility, as in the American colonies. Moreover, such slavery was consistent with Christian liberty. I would love to go through all the citations, and it's very, very interesting what they refer to, but I shan't. They cite one Scottish author, and that's Lord Bankton. And they cite, Shedden's lawyer cites the passage I quoted last week, where we find Bankton adopting Huber's view that although slavery is contrary to nature, is not contrary to natural law. Bankton, of course, also said that slavery in a proper sense did not occur in Scotland, and that is explained away as referring to, it's not like Roman law of slavery, there's no right of life and death over a slave, as they claim there was in Roman law. But Bankton is also cited approvingly for the remark that there was no apostolic support for slavery's inconsistency with Christian liberty. Montgomery's lawyer argued that whether or not slavery was consistent with Christian liberty was irrelevant. Montgomery, who was baptized, was in a Christian country where, and I quote, liberty and property take place and entitled to the protection of its laws. Okay. So that's the argument before the Bailies of Edinburgh. The Bailies decide in Shedden the master's favour and grant a warrant for the delivery of Shedden to his master. But they delay its execution for 24 hours, and that's obviously deliberately done. And during that period, a bill of advocation was presented to Lord Bankton, whom they've been quoting a lot, and whom they carry on to quote a lot, who is then Lord Ordinary on the bills, seeking letters of advocation and the liberation of Montgomery. And Montgomery's lawyers seek letters of advocation and his liberation from the city guard on his finding occasion to appear and answer. Bankton ordered the preparation of written memorials. And these arguments focus much on baptism. For example, Shedden's memorial quoted Paul's epistle to the Ephesians, stating that commentators understood Christian liberty as, quotes, no other than freedom in a spiritual sense from the slavery and bondage of sin, not from slavery itself. And Shedden's memorial also argued that it was never the intention of Christianity, quotes, to throw men loose from their obligations and dissolve that right which a master has to the labour and service of his slave or servant. On 27th May, after considering the bill and the answers, Lord Bankton and the memorials, Lord Bankton decided to report the matter to the Lords in the Inner House because, and I quote, it is not clear whether the complainer, after his receiving baptism in this country, still remained in a state of slavery. He ordered delivery of possession of Montgomery to Shedden on his undertaking, on a penalty of £50, not to transport Montgomery or send him out of the country. Bankton's interlocutor obviously followed the main line of argument that had been presented in the Bill of Advocation and the letter answers. Did baptism free from slavery? His willingness to deliver Montgomery to Shedden is worth noting. On 12 June 1756, after advising with the Lords, Bankton appointed lawyers for Montgomery. On 22nd June, Shedden signed a deposition, which is entered into the process, explaining why he had not wanted Montgomery to be baptized. And he said this was because baptism was to get free from the bondage of sin and death, but really Montgomery wanted it to try to free himself from his lawful service, being mine lawfully bought. On 26 June, Lord Bankton, after advising with the Lords, issued an interlocutor, granting a warrant to send Montgomery at liberty on bail of £40, and appointed both parties to give memorials to the Lords' boxes by 8 July. This time, printed memorials were prepared, and the Lord Ordinary directed these memorials should be, and the Lord Ordinary, Lord Bankton, directed that these memorials should particularly attend to the effect of natural rights and Christianity on slavery. So the focus is again baptism and Christianity. The memorials were learned and wide-ranging, discussing, for example, the well-known, relatively recent French case of Boucault against Verdun, which involves a slave from Saint-Domingue taken to France. And the claim on Montgomery's behalf was that being a slave was stated to be contrary to the laws of God and of this realm, to the law of nature, of nations, and of humanity. On the other side, Shedden's memorial argued that baptism did not free from slavery, that slavery was not contrary to natural law, that slavery was endorsed by the Bible and argued for by many noted philosophers, including their lawyer mentioned Andrew Fletcher of Saltoun, which of course is correct. After some manoeuvring, the Lords granted Montgomery's counsel's motion for a hearing at the next winter session of the court. We're in the summer of 1756. Shedden argued that Montgomery should be delivered to him, as he was still in prison at Shedden's expense, since no one had found the necessary bail. No one is willing to guarantee the £40 bail to deliver Montgomery from prison. At this stage, Montgomery, now having counsel, Montgomery's counsel managed to persuade 40 people to sign a bail bond for £40. Shedden now petitioned either to have the bail raised to 100 to stop that happening, or to have Montgomery delivered to him on his undertaking not to transport him out of Scotland without an order of the court. Montgomery's counsel now agreed that he should be delivered to Shedden upon the latter's finding cation, first not to transport Montgomery out of the kingdom without a valid judgment of the court, and secondly, not, and I quote, to use the said negro with any acts of severity or in any other manner than servants are commonly used in the country, under penalty of £100. The Lords accepted this agreement on 10 August, and on 16 August, Montgomery duly signed a bond for £100 to this effect, undertaking to use Montgomery with discretion. I found occasioner, and the Lords then fixed 4th of January 1757 as the date for the hearing in presence. But the cause was never concluded, because Montgomery, who had spent many months in the city guard, had fallen ill, and he died before the case went to the Lords for their final decision. Now, it's important to stress that Lord Bankton reported the cause on the very narrow issue of whether baptism liberated from slavery, the very question which, as I discussed last week, the English law officers had answered in the negative in 1729. Also, we find in the printed memorials Shedden's lawyers commenting that, and I quote, "Your lordships seemed genuinely to be of opinion that the negro had no claim to his freedom, and that the winter hearing was allowed because, and I quote, your lordships were moved not so much by the difficulty of the case as by the desire of making the judgment that a negro was a slave in Britain as well as in America more solemn." Now, of course, these are the papers for Shedden, who's claiming he was a slave. And so they are suspect. But this interpretation, which is going to the Lords themselves, so they could always say, no, we didn't agree with it. So there's even matter in favour of that. This is indeed what it appeared to be said. But this interpretation is supported by manuscript notes and the copies of the printed memorials preserved in the Signet Library. At the foot of one page, of the lawyers whose papers they were, had noted, it seemed to be the opinion of the Lords that he ought to go back to his master, and even has a little note of who was voting for what, which is very, very difficult to understand. And the same lawyer noted that the issue was, is a negro, upon coming to Britain or being baptized, entitled to freedom? Now, had the Lords rendered a decision that meant baptism did not free from slavery, that would have supported the existence of slavery in Scotland, because they'd been deciding on a narrow question. Indeed, so presumably would have the opposite, obviously. Now, I think, well, it appears, I think, that the litigation came close to creating a precedent that recognised slavery in Scotland. And I think this is probably why the Select Society, the then leading Edinburgh intellectual club, debated the topic of slavery on 21st of January, just not long after the death of Montgomery, and again on the 1st and the 15th of February, 1757. One suspects that this case had provoked both thought and awareness in Scotland. In 1760, George Wallace published the first and only volume of his System of the Principles of the Law of Scotland. He devoted a title specifically to slavery. He mentions the case of Montgomery against Shedden. He argues strongly against slavery, stressing that human beings were born free and that freedom should only be limited when necessary. he had a very powerful argument, which I don't have the time to go into. I'll just, in support of its powers, say that it was copied in the Diderot d'Alembert's Encyclopédie under Commerce des Nègres, if I remember rightly. They copied Wallace's argument, with acknowledgement, I say, they're plagiarizing him. And also, in the same year as George Wallace publishes his book, the Quaker Antoine Bénézet, a French Huguenot who lives in Philadelphia, published his first work opposing slavery and the slave trade. And I mention these to give an indication that that public opinion, I think, is starting to turn against slavery. There have always been people opposed, but there's a greater turn against slavery. And I think in Scotland, this case helped to promote that. I may say, however, that it is after that case that one suddenly finds lots of, well, not lots, that's an exaggeration, when one starts to find advertisements for the sale of slaves in Scottish newspapers. There's only one before this case in 1755. All the rest are from the 1760s, after the Court of Session appears to have come close to deciding that you could be held as a slave in Scotland. I will also say that the Scots Magazine, which is a very important cultural publication of the period, was very obviously opposed to slavery. It publishes many articles in which it never says explicitly it's campaigning against slavery, but we can see that it is. But really, what one needed to determine this issue was not a case that peters out, but a test case, and a test case argued on broad grounds. And I shall come to one that presented that opportunity. This is the case of Dalrymple against Spence, or Spence against Dalrymple. But it's another case in which baptism features very strongly. I'll quickly outline the facts. In 1760 or 1761, when living and working in Grenada, Dr. David Dalrymple of Lindeffren in Fife bought a slave called Black Tom from Ninian Hume, who goes on to be governor of Grenada, indeed killed in the slave rebellion there in 1795. So he buys Black Tom from Ninian Hume in 1761. In 1768, Dalrymple was dying, and he wished to return to Scotland. Tom accompanied him, and the aim was that Tom should be sent back to Grenada afterwards. In Fife, Tom was baptized by the minister of Rheims, Henry Spence, and Tom took the name on baptism of David Spence. And he thereupon absconded, just as James Montgomery had done, indeed just as James Somerset did after baptism. And David, as he now is, took refuge with a local farmer who is described in the court documents as, and I quote, a zealous seceder, okay, someone who is of extreme Calvinist views, who does not accept the authority of the Church of Scotland. Dalrymple sought his return. He raised an action of declarator to have it declared that Spence very clearly was his slave. And this is what the action he asks for in seeking his declarator: the sole and undoubted right and title to the said Negro service and slavery, and asking the court in the order dispose of him as his own property in the same manner as any other Negro slave, and so on. So it's a very direct request that the court recognize the enslavement of David Spence. And so it directly addresses the issue of slavery in Scotland. There are some very interesting things. In the process, there's the most wonderful rhetorical letter written by the zealous seceder to Dr. Dalrymple, explaining talking about baptism and things like this. I would love to quote it, but it's very long, but it is rather wonderful. But the case directly addressed the issue of slavery in Scotland, but again, it's inconclusive, because this time Dalrymple, remember, he's dying, and he dies, and the case just vanishes from the records. But I think, again, on the issue of attitudes changing in this period, I've noted that I mentioned that it was difficult to find cationers to support James Montgomery's liberation from imprisonment until the lawyers went and got 40 people to make a guarantee. But plenty of cationers came forward to support David Spence, who's also been imprisoned, to provide the cation for him. There is a subscription for his litigation, to support his litigation. And also, a number of the advocates offer to plead for nothing. So I think we can see that public attitude and public general attitudes are just starting to change a bit in this kind of way. And of course, around this time, John Miller, professor of civil law in Glasgow, who was to teach many of the noted lawyers in Scotland in the late 18th and early 19th century, he published his arguments against slavery in a relevant chapter of his Origin of the Distinction of Ranks, which is published in 1771. And if you look through the student notes of his lectures, he has been arguing against slavery all through his time at Glasgow. Okay. Well, so we've had two inconclusive cases. One had focused very much on baptism and the kind of problem that the law officers of England tried to resolve. And baptism, just to repeat what I said last week, baptism is a crucial issue because the churches want people baptized. If there was a belief that baptism would stop masters, if there was a belief that baptism were freed, this would discourage masters from having their slaves baptized, and the churches wanted them to be baptized. Well, we now come to Knight against Wedderburn, which proved to be the wanted test case. There are some certain facts and some facts that are not at all certain. Known unknowns, I suppose, the term of, as Haig once said. And those facts that are certain are easy to set out. Joseph Knight was a young African who, aged about 13, arrived in Montego Bay in Jamaica on aboard the slave ship Phoenix, actually, you can trace his journey, on 20th April 1765. He is sold privately to John Wedderburn. John Wedderburn is the son of an executed and attainted Jacobite baronet, and who is living with his brothers in Jamaica, waiting for it to be comfortable for them to return to Scotland, and waiting for themselves to have enough money to re-establish the family amongst the Scottish landed classes. And this they managed to do in Jamaica. In 1768, Wedderburn returns to Scotland. He takes Knight with him, who is very much a great favourite of Wedderburn's. And Wedderburn acquires this as an estate known as Ballandine in Perthshire, near Dundee. Knight was literate, we know, and he was baptised in Scotland in 1772. According to Knight, at his baptism, Wedderburn had promised to free him in 7 years' time if he behaved well, but to free him in Jamaica, interesting enough, and to give him land there. But that's Knight's claim, of course. At Ballandine, Knight started a romantic and sexual relationship with another servant called Anne Thompson, and they had a child. They conceived a child. Wedderburn gave Knight the money to support Anne Thompson's lying-in, which took place in Dundee, but the child died. Knight wished Wedderburn to re-engage Anne or to give them a cottage on the estate. You see, he presumes a bit because he is a favourite. Wedderburn refuses to do either. We know that the couple were married in Edinburgh. Why in Edinburgh? I'm not sure. But they were married in Edinburgh on 9th March 1773 by the minister of North Leith. We also know that Knight had apparently read the account of Somerset's case in the Edinburgh Advertiser. And the allegation is that this led him to believe himself to be free, and he decided to depart. Now, I'm always suspicious about the story, but he's encouraged by the account of Somerset's case, because he is in a position, he is married, but he has no income. He can't live with his wife, and there are kind of obvious reasons why he might wish to depart, I think, other than encouraged by what the people opposing him thought was a foolish newspaper report. On 13 November 1773, Wedderburn petitioned the Justices of the Peace of Perthshire narrating that he'd brought Joseph Knight, a slave from Jamaica, and Knight was now threatening to leave his service, although, and I quote, "the petitioner never gave him any manumission or promised to release him from his slavery further than the law of Britain entitles him to where he now resides." He sought a warrant to apprehend Knight in case he did depart, so that there could be a hearing before the justices to determine Wedderburn's entitlement to Knight's service. The justices duly met at Ballindine 2 days later on 15th November, and their constable, Alexander Fuller, duly produced Knight. But Knight did not run away, he was just always there. Knight admitted in front of the justices that he had no writing from Wedderburn freeing him, but he mentioned Wedderburn's promise to free him. And the justices were James Smith of Balharry, George Oliphant Kinloch of Kinloch, and Sir John Ogilvie of Inverquharity. And they're an interesting group. Sir John Ogilvie owned estates in Antigua, and he was married to Charlotte Tulladelph, the heiress of Dr. Walter Tulladelph, who is a kind of famous figure in the West Indian, who made himself extremely rich. Smith is related by marriage to Kinloch, and his son John is married to Wedderburn's sister. And George Oliphant Kinloch owns a plantation in Jamaica in which he employs James Wedderburn, John's brother, as his overseer. And he himself also owned slaves in Scotland. This is from 6 or 7 years earlier. And as you can see, Captain Oliphant Kinloch, that is Oliphant, he's now of Kinloch, he's acquired the family estate of Kinloch, Oliphant Kinloch. And he owned a Negro slave, 70 years, who runs away. And if you read all the way down, you will see you get the reward if you lodge him in any of His Majesty's jails by applying to Mr. James Smith, Writer to the Signet. And that's James Smith of Balharry, the third Justice of the Peace in Perthshire. Now, I'm sure this didn't really affect their opinion at all, but the justices were concerned to establish whether or not Knight was free or enslaved, and they ruled that Wedderburn, and I quote, was entitled to the said Joseph Knight's service as a servant, and that he must continue as formerly. Okay. They don't actually definitively say he's a slave, they just say he has to continue as formerly. And I mentioned last week, of course, that there's an enormous amount of discretion in the hands of justices of the peace to control labour, and lots of statutes giving them a great deal of authority. So they were, in that way, acting as, at some level, as the law entitled them to. Knight next petitioned the Sheriff of Perthshire, pointing out that in compliance with the Justice's order, he had continued in Wedderburn's employment. Wedderburn, however, he said, refused to give him any wages, and insisted that he continue as, quote, a perpetual servant with them, or in other words, a slave. Wedderburn asked the sheriff to rule that if Sir John did not contract to, Knight asked the sheriff to rule that if Sir John did not contract to pay him wages, he was entitled to quit his service, slavery being inconsistent with the laws and constitution. Wedderburn argued before the sheriff that the issue was res judicata, but Knight claimed that the previous action merely decided that he could not desert the service of Wedderburn. He didn't decide whether he could have wages or not. He should have wages or not. And also he said the current action before the sheriff was to decide that Wedderburn could not hold him as a slave. On the 5th of January 1774, the action was called before the sheriff substitute in Perth, who, and I quote, in respect of the proceedings before the Justice of the Peace, dismissed the process. But despite this claim, he was persuaded to make avisandum to the Sheriff Depute, John Swinton of Swinton, on 2nd of February 1774, who, when the action was called before him on 20th May, issued an interlocutor, which we'll come to later, that made a resounding statement contrary to slavery. And so we start to find the necessary test case emerging from this litigation in Perthshire. There are some puzzles about the litigation, which I will mention at the end. Wedderburn, having lost before the Sheriff of Perth, sought to have the case advocated to the session, and on 7th February 1775, his lawyers and Knight's lawyers, because Knight is a lawyer and advocate, John Maclaurin, argued it before the Lord Ordinary on the bills, Robert Bruce of Kennet, who had also been Lord Ordinary in the case of Spence against Dalrymple. The lawyers argued that Wedderburn had no title, Knight's lawyers argued that Wedderburn had no title to the property through Seward as a slave, even in the West Indies. So they challenged the existence of slavery in the West Indies. There was a short hearing, and Lord Kennet ordered the parties to give in written memorials. Wedderburn's memorial, arguing for the advocation of the cause and the rejection of the Sheriff Depute's interlocutor, was prepared by James Ferguson. Alan McConaughey drew up that for Knight. Wedderburn's counsel argued the law of nature and nations supported slavery and that it was necessary in the colonies as Europeans could not work in the climate. He said he did not claim full slavery, but only service for life, which was different, apparently. And they also said freeing slaves in Britain would encourage the mixing of the races, which was undesirable. Somerset's case was decided on a different point and could be distinguished. Knight's memorial was very much in the style of the famous Brandeis Brief, discussed at some length the background to the slave trade and its development, explaining how the introduction of European articles of luxury had had a bad effect on African manners, encouraging the enslaving of people to sell in order to gain such articles. And to demonstrate this, there was an extensive survey of travel literature in order to show the corrupting effect that the Europeans were having in Africa. On 7th March 1775, Lord Kennet took the case to avisandum of the whole Lords and required the parties to print informations for the Inner House. The printed informations generally followed the line of argument in the earlier memorials. Again, that for Knight emphasised the illegality of slavery according to the law of nature and nations, emphasised in particular the evils of the slave trade and the impact it had on African life, and the nature of the laws on slavery in the colonies were examined to prove that they did not merit recognition in international private law terms by the law of Scotland. Wedderburn's information argued that slavery was contrary neither to the law of nature and that of nations. He had a good title to Knight in Jamaica, and slavery was necessary in the West Indies and endorsed by English and British legislation. The law of Jamaica ought to govern Knight's status. And he also said he also had an equitable claim to Knight's services for life because of the money he had expended on bringing up, educating him, and looking after him. There was now a hearing in presence of the whole Lords in February 1776. It was for several days. The Solicitor General, Alexander Murray, argued for Wedderburn. The Lord Advocate, Henry Dundas, appeared for Knight. And their arguments are reported at length in the Caledonian Mercury. They don't form part of any kind of process because they were oral. Dundas's speech in particular was singled out for praise for its force and eloquence. The Lords of Session now decided the oral argument raised new matters on which they wished to consider in writing. So the lawyers were requested to prepare additional informations. That for Knight was prepared by John Maclaurin and was ready by 20 April 1776. But Wedderburn now starts to delay, perhaps because he's aware that the cause is very much going against him. There are various interlocutors sought for and by Knight's lawyers and granted by the Lords. But it's a delay of well over a year before Wedderburn produces his additional information. It's not until June 1777. The cause is meant to be called on the 2nd of December, but at that date it's postponed to a later date. And that litigation goes ahead on January 1778. Maclaurin's additional information for Knight had emphasised the state of slavery in North America and the West Indies, and again relying on a vast literature to show the evils and injustice of slavery. So it's not just legal argument, it's a great deal of social well, social science of the period type argument to show that slavery was evil. And he also says that you don't need to have slaves. Technology, improvements in technology can get rid of them. And also he said it's untrue that white people can't work in the climate. They also say the law of Jamaica is unjust and immoral and should therefore not be applied in Britain. Robert Cullen, the lawyer for Wedderburn, his additional information argued for the importance of the slave trade economically and for the fact it was authorised under British statutes and charters. He said those who purchased slaves in the colonies were well aware of such legislation and entitled to rely on it, and the court ought to recognise the law of Jamaica. So it's starting to focus in on an international law issue. The Lords delivered their opinions on 15 January 1778. According to the newspapers, they all rejected the existence in Scotland of a status of slavery as existed in Jamaica. They differed, however, on the question of whether a servant could be bound for life. 4 judges, Robert Dundas, Lord President, James Veitch, Lord Elliot, James Burnet, Lord Monboddo, and Alexander Lockhart, Lord Covington, basically were of the view that a state of perpetual service could exist in Scots law, but with a servant under the protection of Scots law. So the master could not send him abroad, that crucial issue, against his will, or treat him worse than a temporary servant. So that's what the newspapers say, but I'm not sure that's entirely correct. I think what the judges said was all rather more nuanced than that. It is clear 8 judges, and the voting 8 judges voted for Knight. 4 voted for Wedderburn. This means the advocation fails. The sheriff's interlocutor stands. But their views were rather more varied and more nuanced, and I've said we have 2 sets of notes of what the judges said, one made by Lord Hales and the other by Maclaurin, Knight's advocate. And they're preserved in the session papers. Dreghorn's are preserved, Maclaurin's preserved in the Dreghorn session papers. For example, one judge who found for him, for Knight, also expressed the view that he might have found differently if Knight had run away from the colonies and come to Scotland. Okay? So, as I said, it's not quite as simple as the newspapers represent when you start to read these accounts. It's very obvious that the judges who were most opposed to slavery were Lord Auchinleck, Boswell's father, and Lord Braxfield, and various others. So it's quite interesting. But those in favour of Knight express different views, and those against him express different views as well. So they're not quite so monolithic. But be that as it may, the Lords issued the following interlocutor. Having advised the memorials and additional informations, they remit the cause simpliciter in common form. And the import of this was to affirm the terms of John Swinton's interlocutor. And as you can see, it's very resounding. State of slaves not recognised by the laws of the kingdom. The regulations in Jamaica are so unjust that we cannot give them any force. And what this has the effect that Scotland has had its test case on slavery. Despite the hedging of the Lords, and to be perfectly honest, in reading their opinions, I doubt if any of the 12 or of the 8 in favour of Knight would have endorsed this in all that it says. But it is clear slavery was now illegal in Scotland. Mysteries remain. How was Knight's litigation funded? He was not in the poor's roll. Are the lawyers doing it all for free? But there are also expenses, rather than just the expenses of lawyers. And he has some of the leading counsel of the period. Did he also have assistance? How did he know that he wanted to get the case before John Swinton? Because there is evidence that Swinton was known to be opposed to slavery. He wanted the case before Swinton because Swinton was going to say something like that. That was clear. The Caledonian Mercury noted, and I quote, that it must give a very high satisfaction to the inhabitants of this part of the United Kingdom that the freedom of Negroes has obtained its first general determination in the Supreme Civil Court of Scotland. It's tempting to end on this congratulatory note, But we must remember the continuing Scottish involvement in slavery until its abolition. And we'd find advertisements such as this. This is 1779, the next year, towards the end of the next year. We have here a runaway, a Negro lad, 15, called Neptune, a discussion of his clothing. And what I would direct you to is, he is under indentures to Mr. Roger Stewart, merchant at Greenock, for 7 years from the 30th of January, 1778. Neptune, within 2 weeks of the decision in Knight, Neptune, who has presumably been a slave, has signed an indenture. But I don't wish to end on a low note either. The case had definitely legal impact. In 1811, Robert Paul, who was accountant to the Commercial Banking Company in Edinburgh and secretary to a charitable foundation which raises money to support education in Africa, was approached by a man called Sandilands. We don't know his first name, he's just known as Sandilands, a good Scottish name, who is described as a man of colour, who had heard of a slave brought from Charleston by his Scottish owners and imprisoned or kept in the lodgings in the Canongate. By the time they attempt to do anything, they have moved to Greenock, where the man is again imprisoned. But he is freed by the magistrates of Greenock. So it's interesting in that to see that the kind of decision made by, in 1778 is being applied. And this, I think, that there are people willing... Sorry. I'm prone to blub. Like Alan, actually, who was very prone to blub. Many times he... It's interesting that there are ordinary people willing not just to accept the law, but to take action. The people are willing to act to ensure that the decision in Knight against Wedderburn was enforced, so that when the slave turned up from Charleston and was kept like a trafficked person under lock and key, an effort was made to free him, involving Sandilands and a charitable society. And they did it. Well, thank you for your attention.